I will introduce my panelists and I'll call them with me to sit here. Ben, Rolla, Paul, and John. Please join me here. And I don't think so we could have gotten a better group of people to deal with the issue that we are dealing with today, intellectual property, because we have people over here who help you understand what intellectual property is. They also help you understand how to monetize it, how to protect it, and what resources government have to help you protect your IP. So I will start very quickly with the introduction. On my extreme right, we have Benjamin Mack. Benjamin is an intellectual property lawyer with one of the North America's biggest law firm called Smart Biggar. I have known Ben for around 10 years now, and anything I know about intellectual property is all from Ben. Ben works with startups, he works with scale-ups, he works with companies with AI, complex technologies, and he has a full array of people who can help you guys protect your IP from the get-go. Next to Ben, I have Paul Cannata. Paul is also is the partner and managing director of Patent Monetization Inc. So if you know you have a patent and you really want to get money out of it, Paul is the guy for you. And he has been involved in monetization of patents since 2009. Paul manages the entire patent monetization process from client acquisition to due diligence analysis through development of comprehensive monetization strategies. So if you need to know where is your innovation, how you're going to protect it, but beyond protection, how it can make you money, Paul is the person to go to. Then I have next to Paul is John Lee. John is a passionate innovator that has helped numerous Canadians identify and protect their innovations. He was doing it so well that TiE thought, we have money, let's get him in. You know what? Let's all get the patents and let's get them protected. And throughout his career, John is named inventor on over 700 patent assets spanning multiple technology stacks, from telecom, mobile devices, banking, payments, and fintech, you name it. And I'm thinking so TiE having you is an asset for them, and that's how Canadian IP is being protected. Last but not the least, the gorgeous woman next to me is Roula Thomas. She's Vice President of IP at Intellectual Property Ontario. So while TD thought they will make all money, government thought, why should we stay back? We will not even charge and protect all the intellectual property while Paul makes them know how to make money out of it. So Rolla has been practicing IP law for over 25 years as a registered Canadian and US patent agent. Since 1999, Rolla has worked in IP in the area of biotechnology and life sciences in private practice at leading multinational law firms and advising and supporting the IP portfolios of a large R&D organization. After doing with the government, with academia, she realized that, you know what, the best way to serve the community and build next generation of innovators is to join the government in Ontario IP. A big round of applause for this amazing panel. If I add everything together, all the years, we have over 100 years of experience in intellectual property here. See, they started when I was not born. So it's not me, it's you. Perfect. So as we have people who are founders, who are building their businesses or about to build their businesses, I actually want to start IP, intellectual property, and more when I talk to the founders, what I hear from you is, what are these confusing terminology? Somebody said, have a trademark. While I was looking for trademark, they told me about patents. When I was thinking about patents, they say, hey, what's your trade secret? Don't tell it to anyone. So Ben, you and I work with founders at all stages. Can you put some light on this very confusing terminology of patents, trademarks, your trade secrets? And if somebody is just launching their business and they want to make the basics about their IP, where they should start? And I know you charge by the hour and you need to make money as a lawyer, but are there any resources we can delve into without paying too much money to start with?
Yeah, thanks, Upasana. Thanks for the great intro. So you may hear, okay, I need IP, where do I start? And you're going to hear all these confusing terms, and you may have even read blogs and sort of mix the terms. And usually the high-level forms of IP being patents, trademarks, copyright, could be trade secrets, could be designs. All of these things may be a bit confusing to you. So just by a really quick example, you can't just say my phone in my pocket or the iPhone is just covered by IP or covered by a patent. There's layers upon layers of IP just in the phone in your pocket or whatever. Or even a more basic example, if you think about Lego had IP, and it did have a patent at the time. It has a trademark, it has some industrial design. And those things all are combined and layer upon each other and overlap. So it's really good to kind of figure out the differences and educate yourself on what you're talking about and where opportunities may lie. So there are great resources. IP Ontario's here on our panel as well. And a big component of their mandate is education as well. So there are, just make sure you read the right resources. Sometimes there's blogs, sometimes the law changes. So just be very careful of that. But just know that, just having, using software isn't enough to protect your IP. You may have to look a little bit deeper.
Perfect. Thank you, Ben. So now, if these confusing terminology makes some sense to you, let's take a step next, and I'll go to John. John, you are working with one of Canada's most active intellectual property program, and you know how people work and innovators develop ideas, and it gets going. So for somebody who's just starting off, how do you help them understand, yes, this is your innovation, this is your business strategy, but buddy, here is your intellectual property strategy, and let's align them. Let's see how they work together.
Right. And so I do work for TD Bank, one of the largest companies in Canada, but I did spend about 6 years doing startups. I have about 6 startups that I did throughout my career. So I understand and appreciate how startups need to focus on IP. And given my background, that was definitely something that we had to consider. I think one of the biggest issues that a lot of startups do run into is they know they have to think about this, but there's very little information or understanding of what that is. And the reality is at the end of the day, patents, IP, it's a tool. It's a tool to help you work your business and to move your business forward. If there is no need for it, there is no need for it, and you don't need to file patents, or you don't need to do anything. However, if there is a business strategy where you do need to protect your assets, that's when you need to take action. And the earlier you take your action, the much better for your company. So I think it's one of those things where oftentimes people talk about a patent strategy, a product strategy. At the end of the day, your IP or patent strategy is in line with your product strategy. Because if your product is launching, you should have done a review to see if there's any assets that are available underneath it. And that should just be parts and parcel for every single product you launch. So I don't like to separate those two terms. I say, really, a good product strategy already includes an IP strategy in it.
So if you have a product strategy, you need to have an IP strategy. We talked about strategy, but it's all about money in the end. Am I right? That's what matters to a founder who's just starting up and resources are limited. And Paul, you have the experience of bringing that financial value to the IP. So with your experiences dealing with so many founders over the years, how do you think if founders have two challenges, how to value their IP and how to bring financial value to them while dealing with limited resources they have, which they can use for operations, which they can use for further product development? How do they balance that?
Yeah, I think that, thanks for the question. I think that one thing that we need to understand about patents particular, that's my main focus, is that it's a right to exclude others from practicing your invention. So what that means is that as you develop your patent strategy and you develop your patents, you need to look at the competitive landscape and what their other products are doing, and understand that your patent, your claims may fall in line with other products out there, and then there's an opportunity there to license your patent to a larger company. Now, some of those things can be a lot more difficult than it is, and helping to find getting funding involved to help you manage a litigation or a licensing campaign. Those are things that you can look for, particularly in the U.S., but you can look for and gain access to help you, so you don't have to spend a lot of your money or resources that can then go to product development, and somebody else can help you along the way to monetize your patents.
Perfect. Now, to We need help to monetize our patents, and I'm sure that Ontario IP can do that. But before I ask you how you can help us for that, you're one person who has vast experience. You've worked with government, you've worked with academics, you've worked in industry, and you've worked with startups, and you've worked with small-sized businesses. What in your experience you've seen over the years that the gaps these companies have in their IP strategy, and how at Ontario IP you think you're helping these founders or entrepreneurs to overcome those gaps in their IP strategy?
Sure. Thank you for the question. I want to back up just for 1 second because I sympathize with everybody in this room. My career started working with in a small law firm, working with startups like the people in this room, and I can understand when we say intellectual property. It's a freaking complicated term. What the hell does that mean? What is intellectual property? To understand your intellectual property, if you guys are all innovators, I'm assuming these are innovative companies. If these are all your innovative companies, you have an innovation. You have to understand, how do I own that innovation? What do I need to do? So at IP Ontario, we do a lot of things. We educate, and we have toolkits and resources and trusted information. You can be sure that what you read and learn from us is accurate. We also have IP coaches, people that are going to sit and talk with you in the language that you're going to get. It's not going to be intellectually, complicated and all this legal jargon. As business owners, you want to know, how is my innovation going to serve my business? What is this thing that I'm trying to develop going to be leveraged? And so one of the biggest gaps that I've seen in working with companies of all sizes is that they really don't link their IP strategy to their business strategy properly. You all need to have a business strategy, a product strategy, a marketing strategy, how you're going to penetrate the market. You guys need to think about that specific to your product. Layering into that, you need to think about, with guidance, with professionals that understand IP, how I'm going to leverage specific IP rights and when I'm going to trigger those rights to help me along my path. So understand your business, understand the IP tools that can be used along the way. That's what IP Ontario does. We work with innovators, we give them the coaches that they need to help them with their innovations, we give them the education, and then we give them the funding. And I'm sure we're going to talk about that later. So understand your business, and then layer in the IP that you need to drive those business levers.
Perfect. So as Roula said, understand your business. Understand the IP levers that you need to run that business. And once you have done that, the next step is, okay, I know it. How do I protect it? So I'll bring Ben back on this at this time, because we need lawyers sometimes. I know with the resources which Ontario IP is, you still might need lawyers. And this lawyer has actually trademarked himself as Patent Storyteller. I know, Ben, your wife must have heard you telling all the stories to your kids. He said, just get focused on your work. So, Ben, I know that storytelling is a very important part. That's how people less complex and less as well-versed in IP like us understand what you're doing. Now, this storytelling, what role does it play, especially when we are dealing with such complex technologies like AI, crypto? Do you think the storytelling help examiners or investors understand the product better and make actually things more patentable?
Yeah, that's a good question. So I kind of coined this term, patent storytelling. It's not that original, but a lot of your technologies, or a lot of software or AI or blockchain, can get very complex. And you have to think about who's going to be the reader at the end of the day. Like, first it's going to be the patent office. It's going to be an examiner. And they do have some technical knowledge, but a future investor may look at your patent and really they want to know, what is this about? You don't want to talk about like high level jargon and jump right into sort of general concepts. There's actually a lot of value in actually telling the story of your invention and thinking about who the audience will be at the end of the day, which could be a judge, it could be a jury, and it could be a counterparty who might want to license your patent. So if they're reading your patent and they think, well, it's just a bunch of box diagrams and some code, they may not actually appreciate the story of your patent and where it's going and the context of where it's in. It's actually very important to think about all facets or all aspects of your invention And it could be deep dives into specific examples. It could be then generalizing it into the inventive idea and then giving the story. And these are going to be humans that are be reading your patent at some point. So, I mean, me personally, I would put in some screenshots or GUIs of what you're doing. If you have results, put those into. So I think all of these components are really important in rounding out a strong patent. And it's not just, a lot of inventors tend to generalize their invention, give some broad concepts and then think, okay, now I'm broadly protected. But actually, providing those details and those stories really help to round out your patent. So that's just from the patent aspect. There's other things for other considerations, but for patents, I think there's a lot of mistakes that can be made and a lot of misinformation out there.
So I'm going to pick the segue. Mistakes can be made. So even when you have taken all the resources from Roula, read about it, got your IP assets identified, then Ben told you how to write a story about it, there's still chances of mistakes. So John, I'm going to come to you with those mistakes. You have helped many companies grow large patent portfolios, and I'm sure there are some lessons of mistakes there for sure. So what are the biggest mistake you see companies make when scaling their patent programs?
So, yes. So I've helped build the programs at BlackBerry, Shopify, and TiE. So I have experience in understanding what that means. And the biggest mistake that by far every company makes is thinking the now. Because patents are slow. Patents last 20 years from the data filing, right? It takes such a long time for a patent to really show its true colors. Oftentimes when people are filing patent, they think about the now. What do I care about? What are my priorities right now? Important, don't get me wrong. It's extremely important to think about what you need to move your business forward. But you also have to consider the long-term impact of having those assets. Because if your company goes through a massive growth phase and it hyperscales, and your needs at that point are different than your needs now. And the biggest mistake you make is, I've done this where I've looked at an asset where I helped draft it or I'm an inventor, and I think about it and it's like, oh, we had considered that use case, but we never put it in. And to Ben's point about storytelling, it's more than just saying, this is my invention, go and protect it. It's saying, how does that invention actually apply in the real world, apply in your industry, apply in other industries where that particular invention could have an impact, right? And that's really an important aspect to think about. And that, to me, that's one of the biggest pitfalls in early innovators or people that start their patent strategy and patent program without really thinking about the long-term impacts of it.
So it's very important, as just John said, the long-term impact. It's not just the industry that you're bringing your product in might have value. Look many years down the lane how it's going to work. And people still fall through the cracks and still do mistakes. And Paul, I'm going to come back to you over here. We are seeing a trend which is emerging where we are moving just from IP protection to actually IP as a growth indicator. We are doing that. And what are those trends that you are seeing in how companies are using IP as a financial or a strategic asset rather than just a legal safeguard?
Mm-hmm. Well, thank you. I want to back up to what Ben had been telling about storytelling. Once you have your patent or patents and you're a long ways and you're building strategic alliances or partnerships, always make sure that you take a chronology of events when discussing with other companies about partnerships or other things like that, helping them understand that you do indeed have a patent, making sure that they understand that you do have a patent and that they've almost been put on notice that you do, so that in the future it becomes a little bit easier to potentially get somebody to finance a licensing campaign or a litigation campaign, because you've marked every stage along the way, and you can show that people have seen your idea, have helped with certain things, but maybe they went away. I've real world experience in companies saying that they've dealt with major companies and then said goodbye, and a year later their technology was built into the larger company's tech. And now what do you do? And so a lot of the trends that are happening now are around financing litigation and licensing campaigns. And there is a lot of money out there for the proper cases that can help you do that. And it's a complicated process. We help a lot of companies navigate that whole process. And from the acquisition of the financing through specialized funders to getting contingency litigation counsel on board so that the costs are very low. But the major trend now is that I think you're seeing a lot more money come in to IP, a mature IP that can be used to level the playing field.
Now that's great. Great to hear all this. So we figured out what our IP is going to be. Ben told us how to tell story about it. John told us look long term so that you don't do the mistakes. And then Paul told us there is enough money if you want to go through it. It is an asset which is valuable. So we got all the theory covered here. But Roula, we are here, we are understanding this concept. And today, if I'm a founder, if I have to take first concrete step to figure out how to protect my innovation, to start the process of protecting it, what the founders should do and how Ontario IP can help them for that first step.
So IP Ontario was launched specifically to help entrepreneurs and innovators understand their IP and protect their IP. You guys have ideas that you want to protect. You need to understand if your idea is protectable, is it patentable, is it new? So one of the first things you can all do if you're not an IPON client is go to IP-Ontario. You can, there's resources there. You can apply. It's free to apply. If you meet our eligibility requirements and you are an innovative company, you're Ontario-based, and you have like you're ready for that love that we're going to give you, there will be an intake process. If you need coaching, we'll match you up with a coach in your industry sector to walk you through some really key important steps. You, as innovators, and I know every innovator I've worked with, every organization I've worked with, they want to know what other people are doing. How does my technology compare to what's out there? What's the green space? What's the white space? Where's the hazards? Is mine better? Why is mine better? What's the value? What do I need to protect? As young founders, you're not going to be able to protect the way the National Research Council protects their IP or the way TD protects their IP. We'll file and just all around it. You guys might have the opportunity to file 1 or 2 patents or a trademark or limited. You're going to have to figure out what are the things I'm going to invest my time, my energy in, and I'm going to focus on those things because those are going to generate my impact. So IP Ontario will help you with that. We'll give you the IP expert. We'll pay for that patent agent, lawyer, whoever to sit and have those conversations with you. We'll help you do a patentability assessment or a search to give you some intel on who's out there, what are they doing compared to your technology. We'll help you file if you're ready for it. You need to be ready for it. You don't want to file and not be able to carry that IP. We'll help you if you're ready to file for it. And the other thing I wanted to mention earlier, you need to make sure if you're in a company of 1, okay, fine. If you're a company of 2, make sure you have some employment. Make sure you have an employment agreement that says you own your IP, that the people working for you, that IP flows to you as the founder, as the company holder. Many companies, you'd be shocked at how many companies don't do that. If you're having conversations with collaborators, and you're going to have to collaborate if you're going to grow, have those collaborative research agreements or collaborative agreements or NDAs in place to safeguard those conversations. Don't tell everybody everything. Only tell them what they need to know if it's in a secure, in a secure way. So these are some things that you will learn along the way. Protect it, own it. That's the only way you can control it.
Perfect. Protect it, own it. That's the only way you can go through. So you've protected it, you've owned it. Paul, I'm going to come to you actually right now after this. Now they have done that, but how do you think that even the founder has taken the right step? They can still make their IP portfolio very attractive for investors.
Yes, to make it very attractive for investors, it's 2 ways. If it's attracted to an investor in the company to help grow the company, the breadth of a portfolio matters, and the claims and what Ben was talking about in putting all the details in there, doing your information disclosure statements, which are what John is saying, where you look at the landscape and see what's out there and what could be called prior art. So from that perspective, doing those things and understanding the specifics of the patent will help an investor in your company. In terms of an investor in the patent that is enforceable, if you're at that stage, it's really about the infringement. It's really about, do we have a handle on what the infringement is? Do we understand the products that are out there? Have we done the claims charts? Have we done everything? Have we understood the story behind it, if there is a really good story behind it? And that will really give you the leg up in getting financing for doing an enforcement campaign.
Perfect. Thank you. Now I'm going to take John as well as Ben on a hot seat for a question which boggles my mind all the time. We know that AI is completely redefining invention itself. There is a massive shift in the world. The speed at which the inventions are happening with the AI is nothing that we have seen before, and we don't know how it's going to change in the future. How are patent offices adapting to it, and what is going to be the new reality?
All right, I'll start, and then we'll see if John has anything else to say. But interestingly, the patent system came in throughout the industrial age. In Canada, it was around 1892. As a quick aside, my firm filed the first patent in 1892. One of my old firm, one of the ancestors, one of the named partners. But so 1892 is industrial age. We're talking about machines, mechanisms, new processes, and new chemicals. But in the early 80s, now we had computers, and the patent system didn't really adapt at that time. Basically, you could just put in computer, some idea or some software, and you can get over some of the initial hurdles that the patent office might give you. Now we're in the AI age. There's a lot happening. You've probably read about AI being as an inventor, and can you patent AI, or can you use LLMs and get an invention? So we don't have all the answers, but it seems like we're going in a favorable direction. The new U.S. Patent Office director is very pro-software and pro-AI, and has actually intervened once or twice himself into some decisions. So it seems like we're on the right track. So we're really trying to evolve the system, which was in the industrial age, now into computers and AI, and really just mimicking human behavior. So that's sort of, I think we're in the right direction. It's really hard to tell, but the best practices will always still apply, whether it's storytelling or the details and trying to justify the invention. But I think we're gonna get there, because frankly, it seems like that's where the money is. That's where all the tech's going. All the new startups are going. So it's hard to say that you can't just patent AI. And there are some, you have to get through the resistance, whether it's the patent office, the judges, and the juries.
John?
I'm going to take that approach slightly differently, because I think the reality is, as entrepreneurs nowadays, especially in the last 2 years, you can't really operate without AI. Every single entrepreneur that I've met in probably the last 2 years, AI has become the biggest workforce that they use in order to support their work and to grow their work. And part of the issue on the IP side, right, is when you ask AI to do something and there's a method, system, or something that comes out of it, the question becomes who really invented this? And at the end of the day, you as a founder, these are your ideas. And quite frankly, you should be thinking about what is it that I'm asking this AI to do, and actually document it. Because if it's documented and you know what it is, and you know what prompts you've used to generate whatever it is that the AI has generated, you have the rights for that protection. There is still an open law, to Ben's point, whether AI can invent or not. Right now it's a no, right? But who knows? At the end of the day, that doesn't prevent any of you from using AI tools. Everybody will be using them. Tools exist for a reason to be used. And just like IP is a tool, right? If there's an AI tool that's there for you to use it. Now, on the IP side, make sure you document it and make sure you understand where you're headed, because there's a whole other host of reasons why, because the reality of a lot of AI systems out there is they're open source. I think there's a question down the road to talk about that. And open source doesn't necessarily mean that you can use it and start using it on a commercial basis. You can experiment it most of the time, but as soon as you convert into a commercialization of something, there are different rules that apply. So part of that is engage a lawyer, right? Have the discussion, understand what you signed up for when you access those tools, and understand how you're going to use the results of those. Because that is fundamentally, at the end of the day, understand what you did and understand what you want to do.
Wow. So in the last 25 minutes, we covered strategy, we covered storytelling, we covered how to monetize it, and where to get the resources without losing anyone here. We are doing something right. Kudos to all of you. So I think so if you're all gonna stick and these guys are here, I want to get one takeaway for all of you as an entrepreneurs. And because you guys have been so nice to us, nobody left, let's make it two takeaways. Okay? So we'll start with Ben and everyone following that. What I want to hear from you is two things that every innovative company should know about IP, or the biggest mistakes they need to avoid.
Yeah, thanks. And I'm going to just try to scare you a bit and give you some horror stories, but
That's how you get your billings up?
Yeah.
Okay, that's what I thought.
And then I can fix it. I mean, the biggest one is patent before publishing, or at least consider patenting before publishing, or else you have stopped your ability to get the patent. And I know there's a big open source community, and people say you should publish and get those ideas out there and share and collaborate. That's big in the software community, but you really got to think about patenting before doing that publication or disclosing. Second thing, adding on Roula's employee agreement statements, look at your co-founders. It's all good right now. Everyone sets up for the marriage, but they don't set up for the divorce. If you have a great co-founder, you call your corporate lawyer, set up 50-50, it's all good. If you look at that shareholders agreement, there's no IP in there. So, they can just take their idea, they can go, leave for another job, they can, there's nothing about IP in that shareholders agreement. So you really need to work on your founders as well as your employees and contractors, et cetera.
I was expecting this answer because for both of these things, you need lawyers. You can't do it without it. But that being said, this is true. In spite of paying them for litigation later, for which we do have money, but it comes with a lot of stress, rather take the steps properly from the get-go. Patent it, and also make sure you have the contracts to protect it. Paul.
I would say from my perspective of the sort of the later stage monetization of patents is always document everything, especially when you're dealing with other companies and alliances and strategic partners, because I've seen it in real life with Canadian companies, with smaller mid-sized companies that are doing partnerships with larger companies, that then they down the road something happens and they don't really have the ability to tell their story because they don't really remember what happened, or they didn't have the opportunity to really show this company that we do have a patent on this, and that sort of beware of the beware sort of. So I think that's one of the major things, and also I would say keeping in mind of what kind of infringement there might be out there, because you get two kicks at the can basically if you're able to grow a business properly with your IP protection and then also license it or enforce it. That can be money that can go straight to the bottom line and be very positive for you. So keep in mind of the landscape that's out there and what possible infringements there might be.
So now when you have patented, look for the infringements, make sure you have documented every step of the way so you know. And John.
So I think one thing that I do want to touch on, which I don't think I've kind of touch on yet. So in my role, I have the privilege of working with about 1,000 inventors on a daily basis. There's about 1,000 inventors at TD. In my career, I've worked with many more. And one commonality in a lot of the great inventors and great innovators is oftentimes they looked at what they've done, at their innovation, at their invention, and their response is, oh yeah, I don't think there's anything new here. And the reality is, have the confidence and the curiosity to ask. There are resources, there are people out there we can ask, hey, this is what I've done, you figure it out. Because if you stare at a problem often enough, everything will seem very repetitive to you. You are the person that came up with the idea, you've stared at it for hours and hours, weeks on weeks. To you, it may not seem new, but I can guarantee you that somebody with fresh eye who understands IP take a look at it, they will find something that's interesting. The second thing, and to belabor the point a little bit, but this roadmap thing, it's so important because oftentimes the lesson that a lot of people as they go through hypergrowth runs into is, well, I didn't consider that. Because of the fact that we're so focused on the now, if you don't consider what an exit looks like, if you don't consider what an IPO looks like for your company, then you're not going to think about how your IP assets or how your inventions and innovations could actually impact those activities. So it's about understanding the future roadmap and understanding how you can leverage these things. Extremely important.
Perfect. Before Roula start, none of them are charging you by the hour, but I still want last 5 minutes of attention here because what you're getting here is pretty valuable. So just wait, we are wrapping up. Give us 2 minutes of more attention. Roula.
I'm going to keep it very, very simple. We all mentioned don't talk about it until you figured out if you want to protect it. Make sure your agreements are in place. Make sure your collaborations are in place as you need them to be. We talked a lot about patents. I'm a patent agent. I'm never going to tell you just patent it. You have to consider to patent or not to patent. What is the purpose? What is the outcome that I want to generate here? There's so many strategies. Sometimes you file to secure some investment. Sometimes you file because that's your core innovation. You better make sure that filing is strong and it's supported and all of the things that need to go into that patent. And your patent agent and lawyer will tell you about that stuff. So you have to make these really important decisions very early on. Don't talk about it. Consult before you make those decisions. And the other thing too I want to just convey here, not every invention is like earth-shattering, like what he was saying. Most inventions are improvements on things that are already out there. What is the thing that you're doing better? Can you sell it? Can you protect it? Can you enforce it? Think about that thing. And sometimes it's a minor thing, but it has massive impact. So these improvements that innovators do are extremely valuable. The other thing I want to say really quickly, sometimes you can't patent anything. You have to consider other rights. Your branding, your trademarks are critical. Your name is critical. The company itself and that brand recognition is sometimes all the IP you've got. That know-how that you can't protect, you can't file to, you can't disclose because you will never be able to enforce it. You have to think about it. It's not all about patents. There's so many different IP right forms that I think we started the conversation with. So think about if you need to patent it, why you're patenting it. And there's so many other forms.
Perfect. You guys have been so nice. And since these guys are not charging today and we are all startup founders, bootstrap, we don't have a lot of money. If Malcolm allows me, can I take 4 questions from the audience? Okay, perfect. Let's start with him. Go ahead.
I do a lot of work in the U.S. and as regards to U.S. patents, Canadian patents, global patents, how does that work? Do you patent in Canada and then nobody cares? Or how does that work?
People do care about Canadians. Don't worry. We are not the 51st state yet. And we will never be. So, but there are other rules which...
Well,
Go ahead. Yeah, you can all.
I mean, so in my entire career, I've made a stance to work for Canadian companies. I had the opportunity to go down to the States. I did not. I stayed in Canada, worked for Canadian companies, filed patents in Canada. That doesn't mean we don't file in the States. So operationally, when you file an asset, you want to get the U.S. right. Because at the end of the day, the patents that you file tells the world that it's something that's net new to the world. If it's net new to the world, you have the right to file in every jurisdiction in the world. And this is where understanding your business is important, because understanding whether you are going to operate under those jurisdictions or not, whether it's worth it for you to file those things or not, is important, right? And there are tools you can use, and the lawyers can talk about all the tools that you can use to make that cheaper or make that faster, or there's things that you can do. But really, at the end of the day, protect where you're operating.
I just want to add one thing to that. Most of you guys, you're going to hear this phrase. You're going to most likely file a U.S. provisional application first. That's probably what most of you are going to do. That doesn't trigger your 20-year clock from ticking. You're going to file a formal application after that, within 12 months of that provisional application. It's going to be a PCT, which is this international type of filing, or you'll file in Canada, or you'll file the jurisdictions that are of interest to you. So your provisional, U.S., and then you're going to file, whether it's your Canadian, your PCT, and you're going to, that's the route that most companies take. It doesn't need to be your route, but that's what most companies do.
You cannot charge, but you still want to add? I thought so. Yeah, so we'll go to the next question. Can I take it here first? Go ahead.
So in terms of costing and globally, how much do these patents typically cost? And I see that that's a big part of what our issues are as small businesses, that we've had these ideas, but each one needs to be protected, and then in these various markets. And then the second part to this, in looking into the future, as you know, the future is happening now, how is tech going to play into how patents in the past were issued and how they're going to be issued in the future?
I'll start on the cost, and then maybe we'll talk about ways to defray that cost. But you can't get a sort of a substantively strong patent without starting with 5 figures. And then, again, you multiply by jurisdiction and maybe splitting the family and things like that. So I would just say to start, yeah,
And
5
Ben
figures.
is really good-hearted. If you really have a good sob story, he give heavy discounts too.
Well, I want to say, I want to add to that, because your first filing is going to cost you, depending on your technology. I come from biotech, and they're the most expensive filings. They're massive documents we file. Most of them are going to be between $10,000 and $20,000. That's your first filing. That's your core innovation. But the great news is the government of Canada and now the government of Ontario understands how expensive it is. We are here to help offset those costs. IP Ontario will pay our clients back 80% of what they filed. So we will help you make those initial filings if you're ready. It's very important to trigger that clock when you're ready.
Perfect.
We support most industry sectors, AI being one of them, biotech, agriculture, health sciences, all of the major industry sectors. They're all on our website. You can apply and see if you're eligible to get support for those costs. But you need to figure out what you want to protect. You can't protect everything. I'm not into just like fire hosing filings. Not a good idea.
No, thank you for sharing this, Roula. At least government is doing something right. Optimism. Go ahead,
Just wanted
Paul.
to add one thing too. Is it, your question about now is, or the future is now, and I think one good thing that you can do, which is a cheaper option to keep a placeholder in terms of a patent, is always file an open continuation. So when you have a patent and it's being granted, you can file an open continuation, and you can base additional claims in the future on the priority date of that first patent. So if it's a core patent to your business, file an open continuation. Now, you don't have forever to make up other things, but if you're innovating quickly, you will always have the opportunity to keep somewhat of that priority date. There are some technicalities around that, but it's a good option, and it's also a good option when companies look at maybe buying your patent outright with a grant back to yourself, is that they have an open continuation to shape the claims on what is happening in the market.
Thank you for that. And I'll do the last question. So with the Black Innovation Zone, what we do prioritize a lot of is allowing the founders to be exposed, right, to things that they would not necessarily have access to. And so I'd love for you all to touch on, because I know there's a lot of founders who don't have any intellectual property. What are they missing? What are they missing not having it?
Well, it depends on whether they can get it. If they're in the business that they can get it, that they need it. I think what they're missing when it comes down to my thoughts about the future as well is that you're missing a potential 2 kicks at the can, because a lot of times, and we've dealt with companies where they ran out of runway, and all they had left were a couple of patent portfolios or a patent portfolio with a couple of patents in it. But turns out that there were a lot of companies that were using that protected idea. So they were able to monetize that even though their company was no longer a running concern.
Ben, you want to add anything?
Yeah, I guess in terms of practicality, just chatting about your business idea at a cocktail party, sending your pitch deck to a wide crowd, like that's not IP, and it's not even protected. So if you say, hey, someone stole this, well, they didn't actually steal anything because your IP wasn't secured. So that's sort of one of the myths that people think, it's my idea, so then it's protected. No, IP is very specific. It's got to be protected. You have to go through the process.
John, you have anything to add here? No. Yeah.
Yeah, I was just going to say, as young companies, your assets are not in buildings and in inventory and all. Your asset is your innovation. That's how you're going to generate investment. That's the value of your company, is in that asset that you need to protect. Nobody opens their door and puts the jewelry on the front step. You need to protect your asset. How are you going to secure it? Think about what you need to protect. Think if you can enforce it. Think about that stuff really early on. That's where IP strategy comes in. That's where business strategy and layering in the IP comes in. IP is, some of you, your only asset right now. You need to leverage that asset to generate funds so you can get some runway. Otherwise, you just open the door and to Ben's point, it wasn't stolen because it was never yours.
John, last word.
I get the last word. Interesting. So what are you missing by not protecting your asset? That's a really, to the point that everybody's making here. It is important, but also remember that at the end of the day, your startup or the enterprise that you're running is your baby. You need to do things about it. You need to protect it. You need to be able to tell the world that you've done it. And you need to do it in a way that's secure. And all those things do stem from having the right IP in the right place, protected the right way. And I think at the end of the day, it gives you the ability to be confident in that the assets that you've protected are yours, and you can tell the world, this is mine, because look, I did get my patent granted for me.
Oh, thank you so much, everyone. This has been an amazing learning experience for me, and I'm sure you all would have learned. So a big round of applause for our panelists. Thank you, Ben. Thank you, Paul. Thank you, John. Thank you, Roula. Only one point I would like to add. Alan Lau recently said somewhere, as we are moving from industry-based economy to the digital-based economy, where we can create billion-dollar companies with 5 employees sitting in 5 different parts of the world. You know what? If you don't want people copying what you're doing, which they can easily now with the AI help, to protect what you have built and to your asset to be protected, only way is to get the right intellectual property. Secure it, protect it, then come to Paul to say how he can help you monetize it. And if you need more money, TD will be there to happy to help you figure out, okay, we'll put more money and help you build. And all these before you go, talk to Ben and Roula. They have the resources and will help you protect. Thank you so much, everyone. We had a great time.